I said where I stopped. From my own side, I have started reading the orders. So I don't know whether we are on the same page with them or I should go back. Council. Hello, Council.
You should go back. With due respect, we think you should go back because, my lord, we think your lordship should go back because we did not hear where the orders. I mean, the paragraph before the orders we never heard.
Hello. Talk loud, Council. I'm not hearing you. You say?
My lord, we did not hear your lordship. After your lordship said that the university abdicated its duty, we did not hear anything again.
Okay. So, from where do you want me to go back? Because from my own side, I know I have started even reading the orders.
We did not hear that, my lord. We did not hear what led to that, what was read before that.
So that's why I'm asking, which part did you hear last?
That governing council abdicated its duty.
Which part?
Governing council abdicated its duty to the two panels.
Okay. Okay. I'm trying to find that area. I'm trying to find the place. Let me start from here. A careful perusal of the defense of the defendant will clearly show that there is infraction of the provisions of Section 20 of the Abuja State University Law, which vested on the governing council of the university the power to take charge of conduct of proceeding of disciplinary action on the alleged misconduct on the claimant. The council was clearly excluded from performance of its duty by the third defendant by directing issuance of queries to the claimant and setting up panel of committee to investigate the claim, to investigate the allegations against the claimant. This undoubtedly shows that the council never notified the claimant of the allegation of misconduct and even invite him to appear before it to defend himself. This also goes to show that, contrary to the assertion of the defendant, the claimant was never accorded fair hearing by the governance council of the first defendant, as he was never notified of the allegations or invited to appear before the council in person to defend himself by making representation. It is also clear from the evidence from Exhibit DWQ letter of dismissal that the council relied on two reports. The council relied on two reports submitted by the side defendant in taking the disciplinary action it's taken against the claimant. The action of the governing council is dismissing the claimant based on the two reports.
This hitch is showing the other way too.
The technical team doesn't seem to really assist the courts. It's just internet now. Technical team should be able to fix this. Technical team, where are you guys?
This one has nothing to do with the technical team. It's the network. It's the Glow network that is not smiling. The Glow network is very, very bad. It's not the technical team.
I'm very sorry, council. I don't know, the network is having problem. So having not mentioned the provision, having not mentioned expressly mentioned the conditions of service, it means it has been excluded. See the case of Okorapo versus Emeka, an Attorney General of the Federation, Attorney General Abia versus Attorney General of Abia State versus Attorney General of the Federation. Therefore, the regulations, the conditions of service is not applicable in this case. It is only the provisions of the law governing the is only the law establishing the first dependent that is applicable and that will apply to the employment of the claimant. Having said that the claimant, having found that the claimant has enjoyed statutory labor, it can only be terminated in the manner prescribed by Section 20 of the Akwa Ibom University Law. I referred to cases of Bamboye, Adeni, and other host of other cases to support that submission. Section 20 has made it very clear beyond peradventure that the process of removal of a member of academic staff, administrative or professional staff of the university, other than the vice chancellor, begins with the council and also end or concluded with the council. That is to say, it is only the council that has power to initiate the process of disciplinary action against an erring academic staff, and it is the council that will conclude that, and not any ad hoc or committee established by the council, as that is not allowed. The only exception is where the claimant himself has asked for setting up of the committee, or 3 members of the council have requested for setting up of a committee. That is where Section 8 of the committee established by Section 8 of the Akwa Ibom State University Law will come into play. Otherwise, no committee has the power to do anything or conduct investigation in respect of any disciplinary action. The power rests and ends with the council. In the case at hand, the council having not notified the claimant with the allegation against him, and having not invited him to appear before it to defend himself, cannot be said to have given the claimant a fair hearing. His fair hearing has been, as enshrined in the Constitution, has been as encapsulated by the doctrine of natural justice, has been violated. In the circumstances, the employment of the claimant world of difference between the council and also the committee of the council or joint committee of the council and senate as established in section 8 of the law. As established in the law. Therefore, the university cannot allow the council cannot allow its powers to be usurped by anybody or person. The facts of this case clear law has shown that the claimant has been deprived of his right to fair hearing. In conclusion, I found that the employment of the dismissal of the claimant from service is null and void and of no effect whatsoever. In the circumstances, I hereby make the following orders. A declaration is hereby made that the dismissal of the claimant from employment of the first dependent is unlawful, null and void of no effect whatsoever. A declaration is also granted that the purported dismissal of the claimant from employment of first dependent negates the fundamental provisions of the Constitution of the Federal Republic of Nigeria as amended, Section 36. A declaration is also granted that the claimant is still in the service of the dependent An order set is also hereby granted setting aside the purported dismissal of the claimant and the letter of dismissal dated 30th day of January 2020 issued to the claimant. An order compelling the defendant to reinstate the claimant and restore the claimant to his post of an associate professor in the service of the first defendant, with all his rights and entitlement to the office is hereby granted. An order compelling the defendant to pay claimant all his salaries due to him from an order the reliefs claiming an order for payment of all salaries due to him from period he was suspended until judgment, and henceforth cannot be granted because it is vague, as there was no specific mention of any amount that can be granted by the court. I refer to the case of Dr. Ikegwaha versus University of Jos, where the Supreme Court made it categorically clear that vague order cannot be granted by a court of law. Order 6 is therefore refused. From all I have been saying above, it is clear to me that the defendants in taking the disciplinary, the defendant would have avoided having to find themselves in the positions they found themselves if they have done the proper thing. The counsel has invited the claimant, afforded him fair hearing, and allowed him to defend himself. And whatever outcome of the decision of the counsel cannot be disturbed if such an opportunity has been given to the claimant. Alas, in this case, the defendant failed and refused to afford the claimant fair hearing. That's why his dismissal is hereby nullified. I have also observed from the final address of counsel that some references were made, but the actual references were not supplied. In some instances, counsel will say, I rely on the case, but will not supply the case. Or he will rely on the provision of the law, but not supply the law. He will only put dash dash, or that he will rely on exhibit and push dash dash without putting the exhibit. It is wrong for counsel to be making such kind of address. An address before the court should be clear and unambiguous, and references must be proper and correct references, and not imagine references. From all I have been saying is that counsel need to be more circumspect in filing address by ensuring that all references are correct references made. With this, I come to the conclusion of the judgment. The judgment and orders made are hereby entered accordingly. I make no order as to cost parties to bear their respective costs. This is the judgment of the court.
As the court pleases.
Yes, counsel, I'm sure you will get copies of the judgment will be online, but the hard copies may not be available immediately, but by the grace of God, by Monday, the judgment, or before Monday, it will be online. It's because tomorrow there will be public holiday. Otherwise, it will be online by tomorrow. But I'm sure by Monday or before Monday, it will be online. You can access it online before getting the hard copy. I thank you for being with us throughout the period of our challenges now. I don't know what happened today. The network. I had never found it like this before. Yes.
Well, my lord, it's one of those things with the internet. My lord, on behalf of the defendant, I thank His Lordship for the judgment of the court.
Yes.
Just to point out something.
Yes.
The person that chaired and signed the document of the staff disciplinary committee was actually the chairman of the governing council of the university. Dr. Gloria Ukbong was actually the chairman of the SDC, which is the SDC is the governing council, is an arm of the governing council. But my lord, we have heard the judgment of the court, and we shall advise them.
No, SDC. I have stated in my judgment. I followed the judgment of the Supreme Court and the Court of Appeal. The Supreme Court made it clear in Bamboi, the council is the one in charge, and the disciplinary committee was not the council. So you cannot say that because the chairman of the council chaired the SDC, then it becomes the council. It cannot be so. There are two different things. If that is the case, why did you refer the said report to council?
As the court pleases, we are grateful to the court for judgment.
Why did you refer the report to the council? And I have quoted recent judgment of the Court of Appeal, just delivered on 27th of January 2025. Court of Appeal decision in Jos, University of Jos versus Suwanko. A similar scenario played out, where the Court of Appeal says that all those council, all those, council, senate committee, or whatever, they are not recognized as per the law. They are not recognized. The only recognition is that under Section 8 of the law. And in that case, the claimant himself must ask for the setting up of the investigation committee, or 3 members of the council will ask for setting up of the committee. And in this case, none of them has asked for setting up of the committee. So that out of it. If you now said you refer the report to the council, what the council ought to have done was to now serve the claimant with the notice of those allegations contained in those in those reports, and now invite him to appear before the council and exculpate himself. So if he has done that, it would. If the council has done that, it would have done. Even if it is one member that sat, it would have served the purpose. But the council did not do that. The council, if after receiving, what the council should have done is invite him, then now constitute a committee. Let the committee go and interrogate the claimant, but they did not do that. So they cannot rely on the SDP or whatever, SDC committee. They cannot rely on it without notifying the claimant. That is the catch word. The Court of Appeal has made it very clear. And in the Bamboye's case, the Supreme Court said the council is not bound by those reports. You know, in the case of Bamboye, there was a report of the SDC that he should be reinstated. But the council invited him to appear, and they confronted him with the allegation against him, and he now admitted before the council, and the council dismissed him, and the Supreme Court affirmed it because the council followed due process in that case. But in your own case, the council did not invite the claimant, did not serve him any notice of those allegations. The only notices served on him were the queries. Served on him on the directives of the Vice Chancellor. And the Court of Appeal has made it clear that that is wrong. So my decision is based solely on those 2 cases. We are built on those 2 cases. the Pamboye case and the University of Jos versus Wanko.
As a couple,
but it is good. It is good to test the judgment in the Court of Appeal. I wish you all the best.
We do not know that.
Very much.
As counsel, I do not know that at the moment. It will depend on my client. My lord, I'm sorry. One other thing. One other thing which I want to correct is this.
Yes.
My lord made reference to the fact that counsel had submitted address without citation and the names of exhibits. My lord, I sent
it is in the
what
address.
I sent to the clerk. What I sent to the clerk of court, I sent a scanned copy of what we filed, and all the citations are intact. The one I earlier sent to her, which was the soft copy, that I earlier sent to her was I discovered that was the sketch work I had done. But what was filed, which I scanned to the clerk of court, everything that I made reference to is there. And my lord, if the court checks the file of the court, my lord will see everything. I did not leave any space in what I filed before the court.
I'm trying. I know I have checked the hard copy. There were places where you made references, but you did not supply the references. This is your address. Let me show. Yes, like page. Okay, you did not have. You did not page it. Okay, page 14, page 15, paragraph 3. You said he offered comprehensive response to the petition against him. Exhibit. You say dash. You did not put the exhibit there. And that is not the only one. You say? Yes.
My lord, what I have, what I have, the exhibits.
At least I have shown you one now, but I know it's more than one. I have shown you page 15. If you check page 15, you will see where you put the exhibit dash. You did not put the number of the exhibit.
My lord, on the day of adoption, I still remember. My lord, on the day of adoption of that address, before your lordship, I asked about the number of that very exhibit. And my learned friend on the other side said that he has already tendered it. And his lordship said, I shouldn't bother. That is what his lordship said. I shouldn't bother, that he will find that in.
You shouldn't have stated it in your address. That you are relying on it, you push dash. You should have waited when you receive it.
I remember raising it.
And page 10. Page 10. You also said that the said reply to query was tendered and marked exhibit. You put dash. You did not put the exhibit. And I know I have seen even where you cited case without giving the citation.
It's just okay, my lord. My lord, as a court, please.
It's an observation. It's not part of it's just an observation. It is not part of the ratio.
My lord, I raised it. My lord, that very one, I raised it on the day of adoption, and it was his lordship that said I shouldn't bother. That is in the record of the court. I actually raised it that day, my lord. The record of the court would show. But my lord, we are grateful to the court. We will relay this to our clients, and whatever be the decision of our clients, we shall follow that. Thank you, my lord.
You are welcome. Yes, administrator, you can end the sitting. We have come to the end of the sitting.